This podcast is brought to you by the School of Advanced Study, University of London.
Right, good evening everybody. We're going to start off with our first seminar in the series, and we're very honoured to have Chaloka here today. This is Professor Helen Lambert as well. She'll be chairing the session and she'll give you an introduction shortly. I wanted to tell you a little bit about what we've got lined up for the coming year. We've got a number of events as part of the same series, and in November we've got one of our visiting fellows who will be speaking to the Southeast Asian region on securitization issues. So do come along to that. We've also got some brochures in the front to give you an idea of what kind of events that we have going on. And we have a conference coming up. We have a number of workshops coming as well. This year we've tried to look very much at specific issues. So we've tried to, this particular, the International Refugee Law Seminar Series is going to be regional. And we've got another very exciting event in the new year that's going to speak to issues in the Middle East. If you have any questions, I'll be around. You're more than welcome to come and speak to me afterwards. We have a reception as well, and all of you are welcome to it. And for any other queries, find me and I can talk to you in more detail about it work. So I won't keep you now. Welcome, please go ahead.
Well, I'll introduce the speaker for this evening, and it's, as was just mentioned, an absolute honor to welcome Chaloka Beyani, senior lecturer at the London School of Economics, where he lectures in international law and human rights. He's a graduate from the University of Oxford and the University of Tanzania. Oh, Zambia. Yes. Ah. He has taught international law and human rights, as well as public law and criminal law at both these universities. He is a visiting professor, and I hope I get this right, at the University of Toronto and Santa Clara University. Chaloka is also, of course, the UN Special Rapporteur on the human rights of internally displaced persons since 2010. He has served as a legal advisor and expert to the Office of the High Commissioner for Human Rights, the Office of the UNHCR, the World Health Organization, the UN Population Fund, the UN Development Fund for Women, the European Union, the Commonwealth Secretariat, and the African Union. Chaloka was a member of the high-level panel of eminent persons of the African Union on the formation of an African Union government. He was a member of the joint African Union and European Union ad hoc group on universal jurisdiction, and he is currently a member of the UK Foreign Secretary Advisory Group on Human Rights. Chaloka has practical legal and political experience in making national constitutions. He was a member of the official committee that drafted and prepared the Constitution of Kenya, which was then adopted by referendum in 2010. He also has practical legal and diplomatic experience in treaty making, having drafted and negotiated the adoption of the African Union Convention for the protection and assistance of IDPs in 2009. He also drafted and negotiated the adoption of 11 peace treaties under the framework of the Pact on Peace, Stability and Development of the Great Lakes regions in 2006. As an academic, Chaloka has also made significant contribution to scholarship. Amongst his many publications, two of his books stand out. The first being the Human Rights Standards and the Movement of People Within States, which was published by Oxford University Press in 2000, and most recently, Protection of the Right to Seek and Obtain Asylum under the African Human Rights System, which was published this year by Martinez Nijhoff. And I believe it is the topic of Chaloka's presentation tonight. So without further ado, I now leave the floor to Chaloka Beyani.
Well, thank you very much for your kind introduction. Most of the things you say I actually don't remember. Therefore, will blur in my memory. And thanks for the invitation to come and speak this afternoon. And may I just say that I profoundly recognize the presence of Professor Barbara Harrow-Baum sitting in front here, who was one of the great stimulators of my interest and progress in this field. I did work at the Refugee Studies Centre for some time as a Crown Prince of Jordan Fellow in International Law and Human Rights. So I found my appointment as Special Rapporteur on IDPs slightly something of a betrayal to refugees, but at the same time I think that the two subjects are actually linked. I just came back from a mission to Serbia and Kosovo on Sunday, and I found there in collective centers refugees and IDPs sharing the same premises, and solutions that are being sought for refugees and IDPs in terms of housing are basically the same, and they affect both categories. Having said that, of course, significant differences still remain. It's tempting to say, well, just read the book, but at the same time, it's also hard to convey something that's in a book within about 40 minutes, but I'll try and give the flavor of what it is that I actually sought to do. The book is not an ordinary academic book. It's actually based on field experience, practice, and research of a period of time by a grant that came from the Ford Foundation, the purpose of which was to enable refugees to use the African human rights system. Therefore, we had field missions to West Africa, East Africa, Central Africa, and Southern Africa. And first we prepared a manual on how refugees can use the system and how NGOs could also use the system. And it had a great impact in the sense that after the manual was prepared, quite a good number of cases involving asylum seekers came before the African Commission on Human Rights. But I also thought to share that experience and therefore decided to write it out in a book. So when you read the book, you find it's a mixture of theory, practice, and concrete examples and case studies that came from both West Africa, East Africa, as well as Southern Africa. So I'm therefore delighted to be able to speak on this subject. I didn't choose the subject. The organizers of the seminar invited me to speak onto it. And I've noticed that there's an avalanche of interest in human rights systems of refugees as we speak. I think there'll be another seminar at the Institute around the 14th or 15th of December. There was a seminar in Brussels around June. So I think it's a growing area of interest to see how regional systems complement an international system for the protection of refugees. For the records, there are about 14 to 15 million refugees worldwide, and of these, 6 to 7 million are in Africa. So Africa obviously enjoys the largest proportion of the responsibility to protect refugees, and at the same time it's also a global responsibility. And the fact that the majority of refugees are in Africa does not mean that other states do not have obligations towards them. It's important to note why refugees are a special category of protection. From the history of the evolution of the system for the protection of refugees, from the biggest states onto the expulsion of dissidents by the Soviet Union in the 1920s, when about 800,000 persons in Europe had no state to go to, and the world for the first time was in a dilemma. International then did not know how to protect people who were not connected to states. It protected nationals. It also protected foreign nationals who had been lawfully admitted in states. But the creation of some 800,000 people who were basically without protection became an anomaly. And therefore, a conference was held by the International Committee of the Red Cross in 1922 to look at this. And the solution to this was the recognition of the category of refugees, i.e., those former nationals of the Soviet Union who no longer enjoyed the protection of the Soviet Union. Later, this was applied for Armenians in 1926 when Armenians were expelled out of Turkey, and the same formulation was used. Since then, I think it still is very important to note that a refugee is basically an individual or a person who's without protection. and the system for the protection of refugees in international law is to bestow protection to those who are in need of protection because they have no protection. And that's important. Most of us are usually protected either by our own states, we may be foreign nationals, but once a foreign state admits you lawfully into its territory, it is lawfully bound to protect you, which is why if you open up your passport, you find the very first page says, the government of state X requests that the bearer of this passport be given transport, protection, and everything else. That's a principle of international law, which tells you that by lawful admission, the admitting state assumes protection on behalf of the state of origin. And nationals such as IDPs, of course, remain protected. But IDPs, refugees, are essentially without protection, and the system of international protection of refugees is to ensure that these individuals are protected. The international instruments on refugees circumscribe the ambit of protection, notably the 1951 Convention relating to the status of refugees and the 1967 Protocol relating to the status of refugees, the African Union Convention governing the specific aspects of refugees, 1969, and the Cartagena Declaration on Refugees, 1984. All of these collectively embody international refugee law. The differences being that the 1951 Convention is based on individualized circumstances of a well-founded fear of persecution based on convention grounds, race, religion, membership of a particular social group, or political opinion. In the circumstances of the 1940s, given the history of the persecution of those from Russia, from Armenia, and of course Jews during the Second World War, and in the period during the Second World War, the persecution-based criteria found itself in the 1951 Convention, but very much on individualized grounds and circumstances. The experience in Africa and Latin America was somewhat different. In Africa, the wars of independence and national liberation were such that persons fled in large numbers, such that it was not possible to individualize them. In Latin America, in the 1980s, dictatorships had a massive effect on violations of human rights, and therefore all continents took the view that refugees would be admitted on a group eligibility basis, i.e. persons compelled to leave their places of residence, amongst other grounds, external aggression, foreign occupation, events seriously disturbing public order, and of course massive violations of human rights. And this was the admission from those two instruments. Given that background and the sources that apply, then the question is, where do human rights fit in, and where does the right to seek and enjoy asylum descend from? It's evident in Article 14 of the Universal Declaration of Human Rights, which states that everyone has the right to seek and enjoy in other countries asylum from persecution. It's noteworthy that the Universal Declaration of Human Rights in 1948 used the term persecution before the 1951 Convention was adopted a few years later. And I think that history is something that is important to look at as we try and do later. The right to seek and enjoy asylum is based upon the notion of asylum, which is the protection accorded by a state on its territory to those who come to seek it, and hence the right to seek and obtain asylum. But it's extrapolated from the Greek word asylum, which means free from seizure, or that which cannot be seized, because the Greek states had the practice of offering asylum in monasteries, in schools, and other places during the time when international law was emerging in the early stages. And the inclusion of asylum, therefore, in the Universal Declaration of Human Rights did have its roots to the practice of the Greek city-states. But what effect did this have? First of all, it reconceptualized the notion of asylum. After the 1940s, and largely by some state practice, asylum is seen as the right of the state to grant, or a discretion on the part of the state to grant to individuals who come to seek it. But what the Universal Declaration of Human Rights attempted to do was to reverse the situation and empower individuals so that by entitlement they had a right to seek and obtain asylum. And the right to seek and obtain asylum was not alone in that regard. The Universal Declaration of Human Rights also included the right to nationality. And until then, the granting of nationality was also seen as the sovereign prerogative of the state. The right to own or enjoy property also appeared alongside, and until that time, property was within the reserved domain of states in order to do as they wished. So the Universal Declaration of Human Rights therefore did have a transformative effect in the way in which asylum is seen. And therefore, inevitably, it reshaped a state-centric system of international law applicable purely between states to one inclusive of the protection of individuals from the point of view of human rights. But this became problematic both in conceptual and normative terms. The right to seek and enjoy asylum was said by many refugee scholars to be empty of content, that it actually didn't mean anything in view of the 1951 Convention, as well as the protocol and the other instruments. Although the 1951 Convention was a subsequent development of the Universal Declaration of Human Rights. The right empowered individuals to seek asylum so that individuals were no longer passive objects, and the right to seek and enjoy asylum then also became applicable as against the states of origin in human rights terms, whereas the 1951 Convention remains purely a responsive framework, something that reacts to events and therefore simply looks at outflows of refugees as they occur. But part of the benefit from human rights is that individuals can make claims against the state of origin for making them refugees and for violating their rights. They may also make claims against the receiving state if the receiving state does violate their rights. So it's a double-edged sword in that sense, capable of cutting across both the state of origin as well as the receiving state, whereas international refugee law has remained predominantly a system of response to those who need protection. But this also means that there's a duality of legal regimes. That is human rights in relation to individuals as a human right on the one hand, and international refugee law, which is state-centered in terms of the discretion and power of states to consider requests for asylum and to grant them or not to grant them as such. And this is seen in the the Declaration on Territorial Asylum of 14th December 1967, a resolution by the General Assembly which had not been implemented and which for some reinforced the notion that the right to seek and obtain asylum was simply a letter-based right. Article 1 of that declaration did state that asylum granted by a state in the exercise of its sovereignty to persons entitled to invoke Article 14 of the Universal Declaration of Human Rights, including persons struggling against colonialism, shall be respected by all other states. In a sense, that was a fudge in trying to conflate the right to seek asylum at the same time, acknowledging the sovereign power of states. Human rights has attempted to reconcile these two strands of law, and the first reconciliation came from the American Convention on Human Rights 1969, Article 22, Paragraph 7, which clearly states that every person has the right to seek and be granted asylum in a foreign territory in accordance with the legislation of the state and international conventions in the event is being pursued for political offenses or related common crimes. So the reconciliation there was, yes, there's a right to seek and obtain asylum, but it's in accordance with the legislation of the state and of course in accordance with international conventions, that is the 1951 Convention or the Cartagena Declaration as the case may be. It's also telling that the American Convention did not use the term persecution. In the event is being pursued for political offenses or related common crimes. So it was fairly acknowledged that common crimes as well as political offenses were the problem. By the time the African Charter on Human and People's Rights was concluded in 1981, it basically borrowed the same formula in Article 12, Paragraph 3. Every individual shall have the right, when persecuted, to seek and obtain asylum in other countries in accordance with laws of those countries and international conventions. More or less the same formula, except that here it does state literally when persecuted. And in my earlier years when I was looking at this, I was very critical of it because the difference between when persecuted and a well-founded fear of persecution is that a well-founded fear of persecution enables protection before the horse's bolt, as it were. But when persecuted, suggests that you actually have to show evidence of persecution. But as I got involved in printmaking and started looking at words in French and in English, I found that this was a crude translation from the French text of the African Charter, because the African Charter had actually been drawn up in French, and the translation was lost. And hence the term became when persecuted, when what it actually means is a well-founded fear of persecution, as it were. So this existence is therefore critical in terms of, first of all, the elements of the right to seek and obtain asylum, and on the other hand, in accordance with international conventions, and to try and unpackage this. The first entry here came from the Inter-American system, and on whose jurisprudence the African system has relied upon. In the Haitian interdiction case in 1997, some of you will recall American policy to intervene and stop people from Haiti from arriving on American shores. And when this was tasted in the Supreme Court of the United States, the Supreme Court decided that the practice was actually lawful because no one exercised jurisdiction on the high seas. They invoked the principle based on the law of the sea. But the Inter-American system disagreed and said actually this was a breach of the right to seek and obtain asylum. And they then disaggregated the two elements and said that the right to seek presupposes access to safety, access to state territory in the first instance, in order that asylum seekers arrive on the territory of the state and have access to status determination processes and procedures, and that they are entitled. This is reinforced in the African Union Convention governing the specific aspects of refugees in Article 2, which say that the principle, there shall be no rejection at the frontier of asylum seekers or those who are coming into the territories of states to seek refuge. So the two then are in tandem. It's also reinforced by Article 31 of the 1951 Convention relating to the status of refugees, which speaks of no penalty for illegal entry on the part of refugees coming directly from a country where they have a well-founded fear of persecution. So in this sense, we see a reconciliation of both international refugee law and also of human rights in relation to the element of seek. The element of obtain is based on status dissemination or recognition of refugee status, so that once a person is lawfully recognized as a refugee, then at that point, they obtain asylum and then the right to enjoy asylum, as it were. But if that particular determination is not in their favor, then of course they can proceed in relation to enjoying or obtaining asylum, and other principles such as non-refoulement might then apply in that regard. So the right to seek and enjoy asylum is obviously subject to the determination of refugee status, as it were. And I think that the right has to be seen in the context of regime theory in international law, whereby a treaty is approached as an integral whole. So we simply don't look at the right to seek and obtain asylum, but we look at other rights within a human rights framework that reinforce it and that give protection to refugees. And this is the sense in which human rights has been termed as providing complementary protection to refugees, in the sense that it provides an additional layer of protection. But there are also those cases where it's not additional. An individual's claim for asylum may actually fail on the merits. But some states in their practice also recognize that they would grant human rights-based protection or status, as it were, so that the person continues to enjoy human rights. They are not a refugee, but the protection and the decision to let them remain in the country is based on human rights considerations, as it were. The difficult, however, is that there's no specific status, and the quality of protection in terms of human rights, especially within European states, then varies from one state to the other. What then is the applicable legal framework in the context of the African Charter on Human and People's Rights? The Charter was formulated in 1981, it entered in force in 1986, And it also carried with it a commission on human and people's rights, which oversees the framework of the Charter. But quite importantly, it carries provisions in Articles 60 and 61 in that inspiration in the Charter will be drawn from international law, international instruments on refugees, therefore applicable, as well as international humanitarian law. So you can import within the framework of the Charter any relevant piece of international law, including jurisprudence and treaties, in order to make the Charter viable. So for example, in the context of a case that was brought by the Democratic Republic of the Congo against Burundi, Rwanda, and Uganda, related to the use of force against the Democratic Republic of the Congo, the Commission applied international humanitarian law in relation to dead bodies that had not been buried. They also applied international humanitarian law and the Convention on the Elimination of All Forms of Discrimination Against Women to determine that sexual violence was discrimination against refugees and others in the context of the Democratic Republic of the Congo. So there's some flexibility in the wide berth upon which the Charter relies. There are the foundations for protection, the basic one being the recognition by the states parties to the Charter of the rights contained in the Charter, i.e. the states parties or member states of the African Union, more precisely, recognize the rights in the Charter. That means that the authority for the Charter does not actually descend from being a state party. And although all African states, apart from Morocco, that decided to withdraw from the African Union for political reasons over Spanish Sahara, are parties to the African Charter. But importantly, it is by virtue of membership of the African Union that the states parties recognize the authority of the rights within the Charter itself. There's then the duty to protect all the rights in the Charter, connoting both positive obligations as well as negative obligations. There are general guarantees in relation to the framework of human rights within the Charter. Non-discrimination, for example, applies throughout the framework of the Charter. And some of the guarantees that have been applied in the context of non-discrimination include expulsion of foreign nationals, whether they be refugees or foreign nationals as such, contrary to due process. And this is something that the Commission's jurisprudence has been fairly heavy on from the time when Zambia expelled certain West African nationals in 1993 and 94. And the African Commission found that there was a breach of the basic guarantees to protect human rights, including non-discrimination, because these persons had been expelled purely by virtue of the fact that they were foreign nationals. It also means that the right to a fair hearing in any circumstance where a refugee has to be heard, whether it's in the context of status determination, where that exists, or in the context of exclusion, or in the context of detention or deportation, that particular right will apply in relation to asylum seekers and refugees. And this is something different from Article 6 of the European Convention on Human Rights on the right to a fair hearing, where asylum seekers are not entitled to, they do not come within the scope of the right to a fair hearing. By interpretation, any claims that an asylum seeker was not fairly heard would not be heard by the European Court of Human Rights. There's also freedom of movement, which is key to flight, but also key to the concept of safe location of refugees in the context of the African system. Here, I think two main problems. The first of which is that all African states, by and large, interpret the principle of safe location more by a criteria of distance, about 16 to 20 miles from the border. But it's not simply about distance, it's also about the quality of protection. So it has to be looked at what distance is necessary to provide safe location for refugees. And there's always a breach of that principle because most of the refugees are located not in safe areas, but close to the border, in view of the contemplation of voluntary repatriation as a solution for the return of refugees, which is problematic. There's protection and human dignity, the prohibition of torture, inhuman and degrading treatment in the context of Article 5, which embodies the principle of non-refoulement. That is the prohibition on deporting or returning asylum seekers or refugees to countries where they'll be at risk of either torture, inhuman or degrading treatment in human rights, or in the specific context of refugees, Article 33 of the 1951 Convention, where refugees clearly would be at risk in the context of certain rights, liberties, and of course the well-founded fear of persecution. But what the African Charter here asks is that non-refoulement, whether as a species of the prohibition on torture, inhuman and degrading treatment, or as a specific component of refugee-related instruments, is also seen side by side with the prohibition on mass expulsions. So in a case against Rwanda, where refugees from Burundi had been granted refugee status before the change of government in Rwanda in 1995-1996, and the new government of Rwanda decided to expel them. The Commission held that this was not just a breach of the principle of non-refoulement and a breach of the right to seek and enjoy asylum, it was also a breach of the principle prohibiting mass expulsions without due process in terms of individualized hearings on the part of the claimants. And so it does follow that a non-national legally titled in the territory of a state party under the Charter may only be expelled from it by virtue of a decision taken in accordance with the law. And mass expulsion is interpreted as that which is aimed at national, racial, ethnic, or religious groups. Other than that, coming to the end so you have a bit more time to raise issues, the advantage that the African Commission offers is that there's flexible standing to bring a complaint. Before the European court system, only a victim of a human rights violation, as correctly interpreted, may bring a complaint in their own name. They may be assisted by NGOs, but the standing relates to the victim. Under the African Commission, an NGO can bring a claim on behalf of an asylum seeker, whether the asylum seeker is concerned to go before the Commission or not. And in part, this was part of the incentive in preparing the manual and the book to enable all those who have an interest in protecting refugees to approach the system and bring complaints on behalf of refugees, because most often they are powerless, they don't know what their rights are. And even when they know what their rights are, when they are in the territories of receiving states, they tend to be rather timid, thinking that if they brought a claim against the receiving state, then they'll be shown the door. But the benefit of using either an NGO or law societies, for that matter, lies in the fact that there's also protection from those bodies. So here, part of the strategy was to create a network of solidarity between refugees, civil society, law schools, as well as law associations would have the ability to spare some time to bring claims on behalf of refugees. It also requires that domestic remedies should not be exhausted before complaints are brought. Most of us will recall that in most human rights systems, including in the African Charter itself, ordinary claims or complaints must exhaust domestic remedies in the first instance. But the Commission has held that this is an exception to the principle in Article 56.5 that domestic remedies need not be exhausted because refugees have no access to remedies in the first instance. So claims can be brought directly before the Commission, and the Commission will then determine the claims. There's then encapsulating jurisprudence in a case known as the African Institute for Human Rights on behalf of refugees from Sierra Leone, for example, against Guinea in 2006, which directly used the manual as it had been prepared. And the refugees in Guinea were actually threatened by the president himself. He threatened to deport them, said their time was up, they were committing crimes, there was instability within Guinea as a result of that, and issued an order that they be deported. And the African Institute for Human Rights, which is based in the Gambia, then went to the Commission and immediately sought provisional measures to restrain the government of Guinea from going ahead to expel the refugees, which they did. They respected the fact that provisional measures had actually been issued, and they waited until the decision was passed, and the decision was in favor of refugees, and stated that if there was any evidence that some refugees have committed crimes, then they should be prosecuted like ordinary persons, but they should continue to enjoy their asylum within Guinea. And if you look at the book, you'll find somewhere on page 82 that case is studied in some detail in terms of what it actually exemplifies under the African human rights system in relation to refugees. What are the cliches? Clearly, the system of compliance and implementation of decisions is problematic, as is the case in all human rights systems, whether they're in the UN system, and indeed the European Convention on Human Rights system as well. There are some outstanding decisions. Deed, Lawrence versus the Czech Republic in relation to Romas and education, where Roma children were being sent to schools or children that were mentally retarded because apparently they were not clever enough to go to the normal schools. And the court came to the conclusion that this was discrimination, and to date that decision still stands pending implementation. And I think we're also aware of the prisoners case on which the Supreme Court was due to rule this morning, where the European Court on Human Rights decided that prisoners actually have the right to vote. And I think there are problems on the part of the United Kingdom to comply with that particular decision. In other words, compliance is not a problem of the African system alone as such. It's a problem for all human rights systems, and indeed it's a problem for international law as a whole. But what has worked measurably within the African system are two techniques. The first is to actually engage the countries themselves where decisions are made against them. To speak to the Attorney General, the Ministers of Constitutional Affairs, and when certain organizations like Interrights based here in London have done that, then results actually begin to happen. So instead of simply waiting for the state to comply, you go to key individuals within the state who have responsibility for compliance and getting them to move. The second is the use of the Special Rapporteur of the Commission on Refugees, Migrants and Internally Displaced Persons, who also has a capacity to go to specific states and get those states to begin to comply with the decisions by the Commission. There have been other cases, of course, not involving refugees, where the organ that is intended to implement the decisions, namely the Summit of the Heads of States, has itself passed resolutions condemning the African Commission for making decisions in certain cases against Zimbabwe and Ethiopia. And the standoff, especially I think around 2005 and 2006, but at least that standoff is being resolved, and the legitimacy of the Commission at this point in time is not an issue. What's an issue, though, is the creation of the African Court of Justice alongside the Commission by a protocol, which means that there's duality within the system. The Commission is created by the African Charter and applies in relation to the Charter. The Court is created by a protocol which requires ratification separately by individual states, and I think there are about 22 or 24 that have ratified it, and the majority of the African states have not. And I think more confusing and profoundly was the bestowment criminal jurisdiction on the African Court of Justice, so that it's not just a human rights court, but it may also exercise criminal jurisdiction, which confuses the character of the court altogether. But this, of course, in light of the political opposition against international criminal justice, and the idea is, well, let's have a homegrown mechanism that will look at international criminal responsibility. On the one hand, just as the African Commission, when adopted and the Charter, it was thought that it would actually never function at all. Let's simply have a homegrown mechanism because Africa was being condemned for violating human rights, left, right, and center. But in the 1980s, after events in Uganda, the Central African Republic, where a number of school children went to visit the emperor and then vanished. They were never seen. And that was also one of the precursors. But nonetheless, the feeling was when we have the charter and the commission, perhaps the condemnations will stop. But the commission and charter are now beginning to bite. But one, I think, waits for the day when if the African Court of Justice, utilizing criminal jurisdiction, indicts an African head of state, then I think that would be the real trial. The SADC tribunal, by the way, was dissolved after it made decisions against Zimbabwe. The East African Court of Appeal treaty was amended when it made decisions against Uganda involving human rights, to remove human rights against it. So what I'm saying is that it's not a rosy picture that I'm painting. I'm aware that even as much as there have been developments with regards to the protection of the right to seek and enjoy asylum, nonetheless, there are still some huge problems underlying the protection of human rights, and also an attempt to have institutions that probably may not function as well as they intended to. The Human Rights Court does not function as a criminal court. It hears cases of human rights, makes decisions on that basis. A criminal court requires permanent jurisdiction and presence, so it has to sit completely at all times. And therefore it will skew the relationship between the human rights chamber of the court and of course the criminal justice chamber. But these are issues that can be explored at some other point in time. Thank you very much.
And Dominic, thank you for keeping it on schedule. So we've got plenty of time for discussion. Do we have any questions from the audience?
Sorry to be legalistic, but you can raise non-legal questions if you like.
Okay. David Cantor had a little practice whereby he would allow the audience a few minutes to think and then ask questions himself. So I will start in the same way and use my powers as the chair. And I was struck by the amount of similarities as well, of course, as major differences between the African and the European system. You mentioned a key difference with regards to the concept of victims, which is very important in the European system. You have to pass the threshold of showing that you are a victim, and therefore you can't really have an NGO bringing a complaint on your behalf to the European Court of Human Rights. Now, this seems to be completely different in Africa, and a very, very pleasing difference. But I was thinking that recently in Europe, the role of diplomatic assurances has gained great momentum and great support, even from the Court of Human Rights in Strasbourg. And one actually wonders whether it is not going to, in some cases it doesn't bypass the right to asylum by just flashing the part of diplomatic assurances, and indeed doesn't deny the right to asylum to certain individuals, or more technically, protection against non-refoulement. And what is, do we have a similar attitude in Africa? Is there a role for diplomatic assurances in this whole seeking asylum issue?
Thank you very much. Let me start from the broad similarities and the differences. They're both regional frameworks of human rights. The European system did have a commission and a court. From 2008 and 9, it was obviously reformed just to have a court. The differences, apart from victim, obviously, is that the substantive rights are fairly narrow. I think it has 15 substantive provisions and protocols in the European Convention on Human Rights. Nonetheless, there's great depth and richness in those provisions. It doesn't have the right to seek and enjoy asylum as such. The negotiating history shows that that was rejected out of hand, but also because of the fact that the 1951 Convention originally applied the circumstances of Europe. So we were confident that the 1951 Convention would sort those issues without having to include the right to seek and enjoy asylum in the text of the Convention. But having said that, Article 3, which simply reads, no one shall be subject to torture, inhuman and degrading treatment, has been interpreted by the court to include the principle of non-refoulement. I think the landmark cases being Chahal and Ahmed at some point, and now we see that this has become a source of great tension between European states and the court. European states wanting to have the liberty to expel or deport individuals to those countries of origin or countries where they are deportable to. And the court having insisted all along that such deportation would be unlawful. Diplomatic assurances were, in the early days, actually declined by the court as not being sufficient. But because of pressure, political pressure from states, they're beginning to look at diplomatic assurances. However, I personally think that the way to go, whatever view one would have, is in relation to the removal of Qatada, where a treaty or agreement is concluded between the deporting state and the receiving state. Because in the event that there's a breach of the principle of non-refoulement, or the person is subjected to torture, inhuman and degrading treatment, there will then be recourse to a remedy in relation to the breach. And I think that I would rather see matters that way. There was a comparable case, and I can take some time until people want to ask questions. There's a comparable case decided by the Committee Against Torture, Agiza versus Sweden, where Agiza was a national of Egypt. They had spent some time in Afghanistan. There was evidence of links with Al-Qaeda. They had sought asylum in Iran and Syria, which had not been granted, and eventually they ended up in Sweden. And Sweden said, well, you are eligible for asylum, but we also find that there are actually grounds to exclude you because of your past history. And here, Sweden accepted diplomatic assurances from Egypt that Agiza can be returned and he will not be subjected to torture, inhuman or degrading treatment. And he was returned, and when a Swedish diplomat visited him in prison, he found visible marks of torture on his body. He had been subjected to torture. And at that point, NGOs then brought a claim against Sweden, which succeeded before the Committee Against Torture, that they had actually removed someone under diplomatic assurances to Egypt, when in fact those assurances had not been adhered to. So that is the danger of relying on diplomatic assurances per se. If the receiving state were to breach the assurances, then the claim goes back to the deporting or sending state. In the context of the African Commission, diplomatic assurances have not actually arisen at all. And I think largely because of the fact that the vast majority of refugee matters are dealt with in the context of the AU Convention, governing the specific aspects of refugees in terms of either voluntary repatriation, return, or refoulement, as the case may be. It's only relatively recently that cases have come up after these initiatives to stimulate interest on the part of asylum seekers and refugees that they can actually use the human rights framework. Because traditional international refugee law outside the framework of the European Union does not have a court to which you could go and say that my rights as a refugee or an asylum seeker have been breached. When asylum seekers and refugees go to court in Africa, as far as I know, the court simply say that you're knocking on the wrong door. You don't apply international treaties on refugees here. Which is why part of this was how do we move beyond the national system and go to the regional system. But in the context of Europe, you'll be aware that under the European Union Treaty, starting from the Treaty of Amsterdam in 1997, there was agreement for the European Court of Justice, no less, to determine claims related to asylum seekers. And claims are being determined by the court, which I actually think plus or negative is a good thing, but there's a direct quote that asylum seekers and refugees get quote. And I think those are the main differences. So diplomatic assurances have not been invoked largely in the context of Africa. There are cases where at least states have reversed their decisions. Botswana expelled someone who they say was not a national of Botswana to a small territory between Botswana and South Africa because South Africa refused to take them. Say they are not a national of South Africa. But eventually, after intervention in relation to Botswana directly, Botswana was able to take this person back as their national. So direct intervention seems to actually be the way to go.
Yes. Could you please expand on the fact that NGOs can take cases directly to the court? But I believe that in order to do that, the relevant countries must have first signed or released that declaration allowing for that country to be able to be taken to the court by these NGOs. I'd like to know what you think about that, please.
Okay, thank you very much for that. Clearly the rules in the context of Article 59, I believe it is to some extent, indicate that one should be victim in the context of violations of human rights. But the practice of the Commission was also to liberalize the notion of a victim in relation to standing. For reasons that not many of the people actually know what their rights are. That's one aspect. They also liberalized the principle of the exhaustion of local remedies. Apart from in the instance of refugees, there may be cases where, given the personal circumstances of the claimant, their education and state in life, they may be given time to file applications outside the period of exhaustion of local remedies. But there are those NGOs that are formally actually aligned to the African Union and are members of ECOSOC, the Economic and Social Council of the African Union, where all NGOs recognized by the African Union are registered and organized. That's one aspect. There's another whereby the African Commission by itself looks at NGOs and can accredit NGOs to the Commission in terms of their work in human rights, in terms of their standing in human rights. And some of them may not actually be accredited at all. It's simply a question of finding someone who is sufficiently interested in taking their case to the Commission with the support of the NGO or center. In recent times, the minority rights group here in London, for example, interceded in what has become known as the Endoris case in Kenya. The Endoris were a community who were removed from their lands a long time ago, and they claimed that this was a historical injustice, the protection of minorities and land rights, and their case was ably presented by the minority rights group and other NGOs together. They were given standing, and it was actually successful. The Center for Economic, Social and Cultural Rights, which operates out of New York, has been very active in litigating cases against Nigeria and the oil companies in the Nijhoff area. And a number of cases, at least two, actually have been decided by the African Commission. And yet these are NGOs that are actually from outside Africa. So the main question is whether there is a person who is able and willing, or even if they're not able, but they're willing to have their case taken before the Commission. And if they're willing, then NGOs provide the expertise to do that. Provided they are accredited NGOs, that's fine, i.e. registered NGOs wherever they are. But there's also nothing to stop you and I from actually representing someone before the African Commission, if we so wish. And if you identified someone who is in need of legal aid or assistance or technical expertise, you may have a standing before the African Commission, to help or assist them. So they're that flexible in that sense.
Thank you. And firstly, I'm sorry if what I say now we've already started with as I arrived late, but I just wanted to turn to children and the issues related to refugee children. We've seen a lot of positive movement, certainly within jurisprudence in Europe, on articulating the best interests of children within international guidelines, for example, from UNHCR, looking at the specific issues around persecution, child-specific persecution. It seems to me also that there is a stronger framework within the African set of human rights that can be applied to the situation of children, and I think particularly of the African Charter on the rights and welfare of children, which arguably applies a higher standard, requiring states to act in the best interests of children as the primary consideration rather than a primary in the UN Convention. And the Convention concerning the specific aspects of refugee problems in Africa widens the definition of refugee to include those who are compelled to leave their country because of civil disturbance and there isn't persecution. The Children's Convention, the African Charter on Children's Rights, also requires states to desist from harmful traditional practices or to update them and modernise them to make them compliant with human rights. So I wonder to what extent you see across Africa and those states that do refugee status determination, whether these things are being articulated and whether the refugee duties are being interpreted in the context of children's rights.
Thank you very much for the question. It's a very important, significant question, I believe. And you've already highlighted the positive aspects of the African system in relation to the rights of the children. And I'll just add there that there's also actually a committee on the rights and welfare of the child, which oversees the convention and also receives complaints from individuals and children or parents in particular in this context. But as far as I'm aware, they have not yet decided on questions involving refugee children in Africa. And I think by and large the reason is that the group eligibility system of the convention governing the specific aspects of refugees is such that children are admitted as part of families, as it were. And so in a family seeks status or protection in a group eligibility context, that of course is granted. There are specific problems perhaps that the system does not attend to. That is that of separated children. Although they will be accepted amongst refugees, but the best interest of the child would mean that the child be accorded special protection within the system, and that usually does not happen. They may try and trace the village from which the child came from, and if they are refugees within the settlement or camp who come from that particular area or village, then the child will be fostered by those in terms of familiarity, language, and culture. But what is required actually is specific provision for the protection of refugee children. And indeed, both the UN and African Union conventions have provisions that are specific to the protection of children. So I think that should be a matter of advocacy. It should be a matter of great attention, both on the part of the committee under the Charter on the welfare of the child, as well as the protection system. Issues involving children have only arisen in the context of the recruitment of children before the Court of Sierra Leone. That dealt with a number of cases in the context of children. In fact, developed actually the first jurisprudence in those kinds of areas, but it did not go as far as looking at the flight of refugee children. So I think the point is well taken.
Thank you. I was just wondering about with regard to the exhaustion of local remedies. On the one hand, we have this flexibility of who can bring a complaint to the African Commission, but on the other hand, you were saying that refugees don't have access to remedies on the first instance. But I wonder if the African Commission has been explicit about whose duty it is to exhaust local remedies or to prove exhaustion. because I just sort of found that so important.
Okay. The stand or position that they have taken is that because refugees are no longer protected by the country of origin, the country of origin may have violated their rights, which compelled them to flee to other places in the first instance. So if they're bringing a claim against the country of origin, they don't have the means to go back to the courts of that country. If they do so, then the original cause of flight will obviously visit them. And for those reasons, because they're outside the jurisdiction of the country of origin, they're excluded from going back to exhaust local remedies. There's a case, Ouko versus Kenya, for example, where Ouko was actually a student at the University of Nairobi, and his elder brother, who had been foreign minister, was killed in suspicious circumstances. The charred remains of his body were found somewhere in the woods, and this created a great problem. Students were demonstrating, and the brother was amongst those students. He was arrested and detained, and subsequently fled and went to the Democratic Republic of the Congo to seek refuge. But from there, he brought a claim against Kenya, the country of origin. And again, they recognized the fact that he couldn't go back to Kenya to exhaust local remedies because of the circumstances of flight. And it was important simply to admit the claim and examine it without the requirement for the exhaustion of local remedies. It may be a slightly different ballgame if the asylum seeker or refugee will bring in a claim in the country in which they are. There, perhaps to some extent, there may be some justification, but it also depends on whether the laws of the state actually recognize that there's a remedy in the first instance. If there's domestic legislation on refugees applying for the 1951 EU Convention or the African Charter, then you begin to think about the fact that this may be possible to exhaust remedies. But if there's simply a Bill of Rights in the Constitution which does not have the right to seek and enjoy asylum, for example, there may be a case for, again, taking the blanket approach they've taken, that refugees are exempt from seeking domestic remedies because, for the most part, they are vulnerable politically as individuals, and sometimes they actually don't have the resources, to pursue local remedies in the domestic scene, even within the receiving state. There are very few law associations that I've encountered that used to provide legal aid to asylum seekers. Kenya being one of those at one point in time, for example. The ones that I find most are actually UNDP out in the camps who provide legal aid and assistance. And even as I was in Bosnia, I met a group that receives funding from the European Union to provide legal aid to both refugees and IDPs to advise them on their rights, because it's recognized that this is an area which is actually void in relation to refugees.
Looking ahead, with the benefit of the experience that you have drawn from this study, and drawing in particular on the figures, the rather terrifying figures you gave us at the beginning, as to the number of refugees in Africa, and the enormous pressure of the consequence of that, if all were, and obviously not all will, but if all were to complain through these institutions. Can I make another comparison and ask you to look forward to the future? Looking at the European system, in 30 years it has grown and become a victim of its own success by virtue of concentration on another point you made, the concentration on the individual application. You described that as the characteristic of the 1951 Convention, focusing on the role of the individual, and you distinguished that again with the position in the African Convention structures. I wonder whether, given your perspective now and looking 10 years ahead, you would hope to see a different way of development in the African system than the obsession with the individual, which has characterized the European system and become, in fact, its downfall. A system which, however marvelous, taking 7 years to take a judgment, is frankly useless after the exhaustion of domestic remedies. I don't invite comment on that slightly controversial view, but if you accept it, is there a way to avoid the same problem in Africa?
Yes, I think there may be a way. I think that Africa has to look back and see what has happened to Europe in the past 15, 20 or even more years. Because if you recall, there was a commission whose role was to fact-find and look at complaints, and that was seen as duplicitous. There was a backlog, and the way of trying to reduce the backlog was to get rid of the commission. And as you say, the court has become a victim of its own success, because I think currently there are about 300,000 pending cases before the European Court of Human Rights, and they reasonably can't deal with that. They've tried reforms of repetitious procedures and cases of that sort, provide a common remedy, which still it has not worked. So I really hope that looking at that particular experience, the group-based system of asylum should continue to operate as a more effective approach to the protection of refugees in Africa, whereas the human rights system probably should be remedial in character only in those serious cases that cannot actually be dealt with. But having said that, the major gap, and I think that we have to push the African Union here, is that there is no institutional ownership of the African Union Convention governing the specific aspects of refugees in Africa. Yes, it's an African Union Convention, but there's no secretariat, there is no high commissioner around it. There's actually no effective body that implements it. And in order to avoid a situation where many will run to the African Commission or court, I think it's fundamentally important for the states to create such a body and to make sure that it actually has a great oversight and intervening role in the affairs of refugees in Africa. There was a bureau in the beginning that was intended to look at responsibility sharing, education of refugees, but it clearly wasn't fit for purpose. It was dismantled, and it wasn't replaced by anything at all. So there's need for an institutional ownership of that convention, its operational apparatus. Right now, it's seen as a complement to the 1951 convention, which means that UNHCR, on the one hand, says, well, it's not actually our convention. It's an African Union convention, but at the same time, by virtue of their oversight role in relation to refugees, they tend to have some oversight in relation to it. Some challenge, of course, UNHCR standing to do so, since it's not a UN instrument. But that points out the fact that there's actually a void or a gap in terms of institutional apparatus and ownership, which the African system has to own up to.
I'm curious regarding the conceptual. What are the chances, realistically speaking, of human rights protected under the African rights situation?
Well, assuming you were in Africa, you'd have to be within the state party to the African Charter on Human and People's Rights. And I recall that in the early days when the Commission began to operate, people brought claims against the United States, against Bill Clinton, until they were told that, look, it's an interstate process, and so you have to be within the jurisdiction of an African state party. And there are positives and negatives. There are some positives whereby a group of states or some states actually react favorably to the decisions by the Commission, including provisional measures not to go ahead where the action has been challenged already, and not to proceed on that basis. I recall that when a friend of mine who wrote a satirical piece critical of the president in Zambia called him an elephant, and deportation orders were then issued against him. And we went to the missions on provisional measures. Of course, he was in hiding before they could actually deport him. But they respected the fact that they were provisional measures, and they waited until their own court had made a decision. Unfortunately, their own court was in his favor. But There are also others in some earlier cases. The case of Ken Saro-Wiwa stands out perhaps as the most disturbing case, where Ken Saro-Wiwa, who led his community, the Hongkoni, in complaining against the activities of the oil companies, and in that process some people, village headmen, were killed, and the finger of suspicion pointed at him and his movement, and he was arrested, and within 24 hours he was executed. And at that time, the Commonwealth were actually meeting, I think, in New Zealand, and even the Commonwealth had issued a plea not to do so, but the execution went ahead. That was held to be an extrajudicial killing, and if it has any legacy, it is that both Nigeria and the oil companies rendered a deal, from it in terms of respecting indigenous rights. Nigeria actually incorporated the African Charter on Human and People's Rights within its own national law, so that it is law for Nigeria and it can be applied by Nigerian courts as an aspect of that. If you went to Zimbabwe, the prospects may not be very high of complying with a decision of the African Charter on Human and People's Rights on matters of land and property in particular, which are politically sensitive. And indeed, as I said, Zimbabwe, Ethiopia, and Sudan were some of those states that had passed resolutions at the summit of the African Union condemning the African Commission for making decisions against them.
Thank you. I will start by saying maybe charity begins at home. I was wondering, have you ever attended an immigration court?
Which court?
Immigration court, courts down here in England.
Yes, I have.
Because we've attended several with Professor Bob Reshaped.
Yeah.
You witnessed that. I was listening to the way you were talking about seeking asylum, seeking for protection, from persecution and everything. But normally, when you're down there in court, okay, normally the burden of proof is on you. But most of the time, it's the person who's persecuting you, the person who wants to kill you, normally doesn't advertise himself in the newspapers or something. That I'm looking for him, I want to kill him or something. But when you go down there in court, that's what the judge is going to see. That's what the judge is going to know. And they want to get it out of you, which is something actually very, very hard. You've been to several courts. This is a country that you could expect should be like thinking straight, spot on, and protecting and whatever. But still, it's not really the case. The refugees or people who are looking for protection, normally the way they are grilled in court, normally in the lower courts. I don't know if you've ever attended any, I don't know if you've seen what really goes on down there. It's not a walk in the park, as like you mentioned, that the person has that free will to seek for protection, seek for asylum. It's really hard. And number two, I don't know, have you ever attended or visited detention centers or something where they keep detainees who are in the process of being deported or in the process of getting just status in this country? Because normally detainees in there, they don't have all that information. Normally the centers, they normally block off all internet access. Bob right here, Professor Bob is a witness to that. Even her website was blocked. She had to make a lot of noise, so we had to open up some streams. And normally detainees in there are like with legal aided lawyers. Those legal aided lawyers, remember, the person who's paying them is the person who's keeping the detainee in the detention center. So how do you really think a detainee really will get the full rights when the person who's paying the lawyer is the person who's keeping you there? Remember, the person who's paying you can decide and say, I'm not paying you anymore. So you either do what I say, or go ahead and not receive any payment.
Well, for the record, I've spent a great deal of time myself in refugee camps. I have witnessed the system and the way it operates here. But I think we're addressing things at different levels. What I'm looking at, essentially through this book, is the way in which regional human rights systems and the African system, by comparison to others, may actually be invoked to determine claims brought by refugees, or for refugees to take their claims in the first instance because they have no remedy at national level. And that is the problem, the central problem that is being addressed here. But if you go to the problems at national level of the type that you're actually describing, there you have to look, first of all, at the general attitudes, I think, of Western states in relation to asylum and asylum seekers. For Africa, you have a dual system. The vast majority are eligible in relation to the group system. But those who arrive in urban areas at airports, life is just a step for them because they have to go through an individualized process through eligibility committees to determine their claims. And even there, the paramount problem is that they have no access to a lawyer in the first instance, as is the problem here. The weakest problem is at the level of the caseworkers who actually handle, the first interview. The interview will go through a series of interviews at different levels. And very often the aim is actually to try and incriminate the asylum seeker rather than let the asylum seeker bring out their story. And asylum seekers have no help, they have no access to a lawyer. So by the time they get to court, the facts have actually been set, more or less, in terms of the story and its origins. And I remember one person I was witnessing saying, they had fled from the DRC through Zambia to come here. And how did you flee? They said, they swam across the Congo River. Why were you not eaten by crocodiles? Was the question, that was posed. And the poor fellow has to try and explain and justify why they were not eaten by crocodiles or how they actually swam across. So by the time it gets to the decision-making process, quite a great deal of damage, if you see what I mean, has been done. So much so that even legal aid, the means testing that has been introduced more recently in the context of legal aid is such that asylum seekers may not meet the requirements of means testing, which means they're without lawyers and without anyone helping them. And by the time it gets to the immigration judges, I know some of the immigration judges personally, and the first thing they'll tell you is that the whole system is chaotic. They themselves, I think, acknowledge that. And of course, it ends with them, unless there is an issue under the Human Rights Act, which has to go to the High Court and other courts. And if there's no issue under the Human Rights Act, most of the cases are foreclosed there. So identify what you say. I actually live in Oxford as well. There's a detention center in Billington. I went there to visit it when it was opened in the early days. So there's a point at which gradually the policy, it actually started after the 1967 protocol. When the 1951 convention applied geographically in Europe and from the events that occurred in Europe after the Second World War, refugee status was meant to be a privileged status, which is why it is a status. And that's why you found in there provisions on naturalization, provisions on preferential treatment in matters of employment. So it was a question of those who were victims in Europe of the conflict and for European states to come around and provide them with protection. So there was a sense of identification with the issue. By 1967, when the debate was whether there should now be another international instrument, the UN decided that, well, let's just open up this convention. After it was already a United Nations Convention. So we removed the geographical limitation to Europe. We also removed the date limitation, so it would apply completely. And that's how come Africa got its own convention, because the move to adopt that convention started in 62-63. The motivation was that the 1951 convention did not apply to Africa in any case. And by the time they opened it up in 1967, the momentum had already grown with the reality that it was still a limited convention, the circumstances of the situation in Europe. So after 1967, I think quite a good number of states began to view the way they protected refugees and asylum seekers, quite differently. And then you saw the policy of detention as being a policy of deterrent in the first instance. It deterred people, from coming, treat them badly. If they didn't make their claim within a week or two in some cases, then they would not be entitled to the protection under Article 31 on illegal entry. They would not be entitled to any kind of benefits. So it has gotten progressively worse, if you see what I mean. And with each election coming, the first thing that changes is an Immigration and Asylum Act. And I'm sure that in the context of the current discussion in the UK, political gains or perceptions made by UKIP will push the agenda on immigration and asylum probably far beyond the dimensions of what exists at this point in time. And it's not just here. You see Australia, you see Canada. Both Australia and Canada were some of the most liberal states on matters of asylum. But Australia changed the system just before the elections again. And then the system of making arrangements to actually have refugees and asylum seekers transferred to other states for those states to determine. Those are all means by which some states have sought to avoid the obligations. But the point to underscore is that from the very beginning, the criteria for determining refugee status was not meant to be applied in an open-handed way. It was meant to be restricted. But the restriction has changed in accordance with the political perception of the issues, and particularly from the shift from the 1951 convention being a European-based convention to a global convention, whereby refugees and asylum seekers then began to go anywhere in the world to seek protection. So I hear what you say, and I've witnessed it for myself.
Thank you. I think we're going to draw this discussion to a close. And if there is any further questions, I'm sure Chaloka won't mind discussing or taking them. There's a little reception, so we're joined. And you're very, very warmly welcome to stay on. But I was told to close the discussion by 5 to 7. We're on time. Thank you very much.